All right, we are now live and on the record for Wednesday morning's April 6, 2022 civil docket. Ms. Orellana, what do you have?
Good morning, Your Honor. I have number 19 and number 20 on your civil docket this morning.
Okay, CL 23669-I, Roberto Moreno versus Frank Mukete, M-U-K-E-T-E et al.
Good morning, Your Honor. My name is Ashley and I'm here for the plaintiff, Roberto Moreno.
Okay.
And good morning, Your Honor. This is Caitlin Logie. I'm here for the defendants Frank and Tina Mukete.
Okay.
And Nick Denzer for defendant Ruiz. I represent the same person that Ms. Orellana represents.
Okay. And what is the announcement, counselors?
Your Honor, on this one, we have mediation set for May 6th with Mr. Mike Zanka.
Okay, and how about everything else with your discovery? Have you guys been able to continue with your depositions, or how are we doing with all of that?
I'm not asking for any depositions, Your Honor. I don't know if the other parties are, but we've been working together and setting up dates for those that have requested. When we've needed to reschedule for whatever reason, we've been able to do so. So we've been working well together.
Okay, so how about coming back? Do you want a June setting or an August setting?
I would say August, Your Honor.
Okay, let's do a status on August the 24th at 9:30. Okay, anything else from anyone else?
No, Your Honor.
No, Your Honor. Thank you.
Mr. Denzer?
Not on this case, Judge.
Okay. All right, then if nothing further on this case, you're excused if you don't have any further business with the court.
All right, thank you, Your Honor. Have a good day.
Thank you, likewise. So on CL 210262-I, Yvonne Cruz et al. Versus Alejandro Villarreal.
Graciela Orellana for the plaintiff, Your Honor.
Is anybody here for the defendant? Okay, what is the announcement?
I guess she left. On this one, Your Honor, we have reached an agreement where we just did it about 2 or 3 weeks ago. So we are working on finalizing the documents.
Okay, then what I'll do is instead of a status, I'll just set for a tickler to make sure that the documents are submitted by May the 20th.
Okay, Judge.
Okay, anything else?
I have nothing further, Your Honor. May I be excused?
You certainly may.
Have a good day.
Thank you. Okay, Ms. Guerra, what do you have?
Your Honor, I have number 17 on your docket, CL 202265, Border versus Landstar. I represent defendant counter plaintiff. The case was referred to mediation, but we just got the assignment of a mediator a couple weeks ago and weren't within the time frame able to get mediation dates that worked for me and opposing counsel's mutually slightly crowded calendar. So we're still working on that. If the court could set us for a new status.
Sure. How much further down the line?
Could we do 30 days?
Yes. Let me see what I have within the 30 days. May 4th, will that work? Or
that'll be great, Your Honor. We should be able to get it done this month. Fingers crossed.
May 4th at 9:30.
Thank you, Judge. I have no further business with the court this morning. May I be excused?
You certainly may.
Thank you.
Okay. Mr. Ramirez, what do you have, sir?
Good morning, Your Honor. It's number 16 on the court's docket.
Yes, sir. CL 192570-I, Jose Manuel Barderas et al. Versus Samuel Rangel.
Yes, and so Ruben Ramirez for the defendant, Your Honor, and plaintiff's counsel is Mario Davila. I'm not sure if it's Rui, but we're here on plaintiff's motion to compel. We've been in contact with plaintiff's counsel to get a date for our client. Our client was indisposed, and that's what the issue was. So we believe it has been resolved, and we have gotten dates for that deposition.
Okay, Ms. Barba, are you here on that case? Okay, you're on mute.
Yes, there you go. I'm sorry. Good morning, Your Honor. Bertha Barba here for Rui Mireles. Your Honor, the reason that the motion was filed is this is a 2019 case. The defendant's deposition has been scheduled 3 times and canceled on the eve of the deposition all 3 times. So at this time, Your Honor, we're ordering that the deposition take place within 30 days. And if it is canceled, that a defendant be sanctioned in the amount of $500 for the cancellation. Because again, this case has been pending for many years, and we would like to move forward with the case.
Okay,
And that is correct, Your Honor. I mean, of course, when we realize that we're not going to be able to continue with the deposition, we make sure and we notify plaintiff's counsel ahead of time just so they won't incur cancellation fees. We have been in contact with my client. You know, when we said it, he does work out of town. So, you know, we are trying to resolve this matter. And of course, I've been in contact with my client and advised him of such. But, you know, it is pretty delicate in the situation that, you know, it's an insurance case as well. So I would hate for the insurance carrier to pull coverage. So I'm walking that very delicate tightrope of, you know, trying to get this case moving without letting the carrier know.
And Your Honor, we understand that. And we ask, I mean, in this day and age, we can do Zoom. We understand that he's working. We're just asking that we be allowed or that it be ordered that the deposition take place within 30 days to move the case.
And I'd be agreeable to 45 days, Your Honor. At this time, according to what my client's been able to tell me, the 45 days seems adequate enough if counsel's agreeable. But if not, I leave it to the discretion of the court.
where does your client work? What does he do?
He works out of town in some oil field. I wish the communication was better, Your Honor.
Okay, well, I have a lot of people that come in here that work out of town and stuff, so.
Yeah, understandable.
Okay, I'm gonna go ahead and give you the 45 days. However, if it is canceled within that time period, I'm gonna leave sanctions open, but I will have a hearing on sanctions.
Okay.
Thank you, Your Honor. I appreciate that.
Okay,
All right.
and then we'll come back for a status. We'll come back on June the 27th
Okay. Thank
at
you, Your Honor.
9:30.
Thank you, Your Honor.
Perfect.
May be
excused.
Yes, you both may be
Thank you.
excused.
Thank you.
Thank you,
Bertha.
Judge. Have a good day. Thank you, Ruben.
God bless you.
You too.
Okay, Mr. Perez, Attorney Martin Perez.
Good morning, Your Honor. I have number 13 on your docket. It's a status hearing.
Yes, sir. CL 180135-I, Maria Banderas Ramos et al. Versus Carlos Herrera et al. Is anyone here for the defense?
Yes, Your Honor, Oralia Guzman for the defendants in the matter.
Okay, and what is the announcement?
Your Honor, defense counsel announced at the last hearing that they had just gotten the case and they were needing a little time to review. We've spoken yesterday. We've agreed to, this case has already been mediated unsuccessfully, but we've agreed to do a second mediation in 60 days with Joe Escobedo. And so we want to reset it for a status maybe in July.
Okay. Anything else, Ms. Guzman?
No, Your Honor, that's pretty much where we're at in this case.
Okay, then let's go ahead and come back on August the 24th at 9:30 and see how far y'all can get.
Yes, Your Honor.
Great, Your Honor. Thank you so much.
Thank you, Judge. May we be
Okay.
excused, Judge?
You certainly may.
Thank you, Judge.
Judge, have a good day.
Likewise. Okay. Ms. Rodriguez, Attorney Victor Rodriguez.
Sorry, I had to unmute. Yes, Your Honor, I'm here on number 7 on your docket. This is Mr. Tony Rodriguez is on the other side, and I see him right there. This
Morning,
is just
Your
a motion to compel. I'm sorry, Your Honor. You want us to make announcements? Victor Rodriguez here for plaintiff.
Tony Rodriguez here for the defendant, Clear Blue, Your Honor.
Okay, CL 220346-I, Noelia Garza versus Clear Blue Insurance Company. And you all have not been able to come to an agreement on your motion to compel mediation?
Your Honor, just for the record, we can't agree on these because simply so it doesn't get used against us in other situations. But Mr. Rodriguez and I have been very successful in mediating cases with Mr. Dan Hernandez. So if the court's going to consider that, I would respectfully request that he be considered as a mediator.
Okay, yes, I'm just
Give me 1 second.
refamiliarizing myself with insurance defense since I had been away from it for a while, but yes, okay, so it is the court's, it is my practice to have parties go to mediation, so I am going to grant plaintiff's motion to compel mediation, and I'll assign Daniel Hernandez to that case, and I'll have him mediate that. Mr. Rodriguez, do you have an order on file?
You're on mute, Vic.
Oh, sorry about that. Yes, Your Honor, that's fine.
But do you have an order on file?
Oh, yes, we do. We'll, if not, we'll submit one today, but I'm pretty sure we do. We usually send one in.
Okay, well then I'll have my staff request that order to be forwarded and for Mr. Hernandez to be assigned to it.
Thank you, Your Honor.
Your Honor, you have a good day. May we be excused?
Let me give you another status for June the 27th at 9:30.
Thank you very much, Judge.
Okay, thank you.
Thanks, Judge. Have a good day.
Likewise. All right, Mr. Denzer, what else do you have?
Judge, I have number 6 on your docket.
CL 21-3746-I, Jennifer Gonzalez versus Jesus Antonio Gonzalez Zapata.
And this is a friendly suit. The plaintiff is pro se, so we helped her prepare all the documents. Mr. Bravo was appointed ad litem. I contacted him. He needed some more time to meet with the mother. And we filed a Rule 11, but I don't know if it was signed by Miss Gonzalez, but we did explain everything to her, and she understands that we need to reset it for a future date.
How much time?
I don't know, Judge, if we could submit a proposed order when we can get it. And I want to give the ad litem time, but I don't know if we should call your court to get a date because we're ready to go. I think it's just the ad litem needs to meet with the minor's mom.
Okay, then go ahead and just file an order resetting hearing and then ask Mr. Bravo how much time he needs. If you can on that order resetting hearing, you can put in there within at least 60 days, 45 days, 30 days, whatever it is that you feel works.
Okay. Thank you, Judge.
Okay. All right, thank you.
May I be excused?
Yes, you may.
Okay, have a good one.
Thank you. Okay, Mr. Oliveira, what do you have?
Judge, it's I'm not sure which case it is on the docket. Maybe Ms. Carranza knows. It's my client is
Number 9, Judge.
Okay. CL 141300-I, Alicia Alonso, ALONSO versus FEMA Enterprises, Inc.
David Oliveira for the defendant, FEMA.
Marisa Carranza Hernandez, Judge for the plaintiff.
Okay, so and your announcements?
Your Honor, we have had some settlement discussions. We have mediated before. What I'd like to do with Ms. Carranza's permission is maybe schedule a settlement conference and see if we can work it out. And if not, then, maybe a half-day mediation with Daniel Hernandez.
I'm in agreement with that, Judge, but we will need some time. My schedule is a little crazy in the coming month. I've got a kid graduating and going to college. So if we could get a reset 60 to 90 days, that'd be great.
I'm in the same boat.
I was gonna say, I think Mr. Oliveira's in the same boat.
Mm-hmm.
Okay, we'll come back on June the 27th and go ahead and attend mediation in the interim if you're ready for it. And since you've agreed to Mr. Hernandez, that's fine with me.
Thank you, Your Honor.
Thank you, Judge.
And congratulations on your kiddos.
Thank you.
Okay, so it'll be 6/27 at 9:30.
Thank you, Your Honor.
Thank you, Judge.
Okay, y'all have a good day. Unless you have something else, I didn't ask.
No, thank you, Judge.
Okay, thank you. All right, Judge Cantu, what do you have?
Your Honor, I don't know if he can hear you or not, but I'm on that case. This is a status hearing, Mark Montalvo. It's a number 15 on your docket.
Okay, CO 191562-I, Spring Valley Produce versus Clock by Green Transport.
Correct, Your Honor.
Rolando Cantu here on behalf of the defendant, Your Honor.
Okay, and what are the announcements, gentlemen?
Your Honor, if the court would just give us a DCC date, I think this case needs to get off center. And I think it needs to be tried.
Mr. Montalvo, any additional announcement?
No, Your Honor, we intend to be filing a dispositive motion in the near future. If we could do this for a minimum of 60 to 90 days out, I would be able to get my motion filed. There have been some previous rulings in this matter, which really there's sanctions involved on discovery that defendants never supplied. And essentially, they have no defenses. So it's just a question of filing the MSJ and moving forward. I just haven't had an opportunity to do that. I intend to get that done in the next 90 days.
Okay. Well, whatever motions are filed, of course, we'll get them set for you. And we can go ahead and hold over the status conference until June 27th at 9:30. And then we'll see what's filed between now and then.
Very well, Your Honor. Thank you very much. We have no further business. May we be excused?
Yes, Mr. Cantu?
Thank you, Your Honor. I have nothing further. May I be excused?
Yes.
Thank you and stay safe.
Good day.
Thank you, likewise. Okay, Judge Reyna?
Good morning, Your Honor. The case is number 5 on your docket, Judge. Marriage of Rogelio Trevino and Monica Garcia. They're both on the camera, Judge. It's uncontested.
Okay.
No children, no property, Your Honor. So if I can put on my client.
Sure. F5028-21-9 in the matter of the marriage of Rogelio Rogelio Trevino versus Monica Monica Garcia. Mr. Trevino and Ms. Garcia, can I please have you raise your right hand? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Mr. Trevino, yes or no?
Yes, ma'am.
And Mr. Garcia, yes or no? Ms. Garcia, I'm sorry.
Yes, ma'am.
Okay, lower your hands. Go ahead.
Thank you, Judge. Your name is Rogelio Trevino,
Yes, sir.
and you married Monica Garcia on or about or do you remember the date when you married her?
I honestly do not recall, sir.
Okay. All right. It was about 2015, more or less, you think?
Yes, sir.
Okay, and you've lived in this county and this state for more than 90 days.
Yes, I have.
And in 2015, you separated from your wife, and you ceased to live together as husband and wife on or about, that's in that year.
Yes, sir.
And then you have certain problems in your marriage that have become insupportable, so that you have a discord or conflict of personalities, and you cannot remain married. Is that correct?
You are correct.
And then you don't expect to reconcile with her.
No, sir.
And that you have no children of the marriage, and you don't believe that she is pregnant by you at the present time.
No, sir.
Okay, and the only property that you have is you've divided that up as personal property, and you're asking the court to divide it in that manner. Is that correct?
Yes, sir.
And you're asking the court for a divorce. Is that correct? And,
yes, sir.
And you have no objection. She's requesting that her maiden name be restored to Monica Garcia, and you have no objection to that.
No, sir, none whatsoever.
Okay, that's all that we have, Judge, and I believe that she's on camera.
Okay. Do you have any questions of Ms. Garcia?
The only question is when can I go change my name?
Hold on, I'm asking if Mr. Reyna has any questions of you.
Oh, sorry.
No, Judge, I don't have any question for her. Ms. Garcia, you're in agreement with the divorce, is that correct?
With what, sir?
You're in agreement with the divorce?
Oh, yes, sir.
And as soon as the judge signs the decree of divorce, it will contain an order regarding the change of name.
Okay, thank you.
Okay, that's all that we have, Judge.
Have the parties signed off on the divorce decree?
No, they have not, Judge.
Okay, just have the party sign off on the divorce decree and your signature submitted, and I'll sign off on it.
All right, Judge, thank you very much.
The court is taking judicial notice of all the documents in the court's file. The court is granting the divorce today and the relief as requested put on the record. The court is further granting the name change, and the respondent in this case, whose name will be changed to Monica Garcia, and that'll be reflected in the divorce decree. All right, best of luck to both of you.
Thank you, Judge.
Thank you. Thank you.
Yes.
Anything else, Judge?
That's all we have. Maybe
Okay,
excuse, Your Honor.
you certainly may.
Thank you.
Okay, Mr. Ray, Attorney Barry Ray, what do you have, sir?
Good morning, Your Honor. I'm here on the case. It's number 18 on your docket. I represent State Farm. It's plaintiff's motion to compel.
Okay, CL 20-2815-I, Daisy Reina et al. Versus Antonio Quintanilla et al.
Good morning, Your Honor. David Solis on behalf of the plaintiffs.
Good morning, Your Honor. Rogelio Garcia for Mr. Quintanilla, defendant.
Okay, and we're here on your motion, Mr. Solis?
We're here for a status hearing and we're here on my motion.
Okay. And what are you trying to compel?
Numerous items. Mr. Ray did provide some information, but it still does not address all of the concerns that I have. So I don't know if you want to go one by one and you rolled after each one, or if you just want to hear everything at the same time.
Okay, why don't I do this? Let me see if anyone has any more quick announcements, since you'll be a little bit longer than that, and we'll go ahead and take you up. Let me see.
I agree, Your Honor. That's why I didn't raise my hand.
Okay, that's fine.
Your Honor, may I ask respectfully if we could go into a breakout room so I can speak with Mr. Solis and Mr. Ray?
Sure, that is always encouraged. Let me go ahead and put you all in a room.
Thank you. Thank you, Judge.
Yes.
You have a new message.
Okay, somebody answer that message. No. Okay,
That's me, Your Honor. Sorry.
it's okay.
It's that message.
All right, you should have the invitation on the screen. Okay, let me go ahead and continue. Mr. Carnahan, what do you have, sir? You'll just need to click that microphone at the bottom.
Now can you hear me?
I certainly can.
Oh,
How can I
thank
help
you for
you,
your
sir?
patience, Your Honor. I'm Chris Carnahan in Abilene. I've got 6 cases on your docket this morning that I'm appearing on.
Oh, okay. So, yes. Let me see if I have any other. I'm going to take you up right now, and let me just see if there's anybody within a quick announcement. Okay, Ms. Max Vasquez, Attorney Teresa Max Vasquez.
Good morning, Your Honor. I do just have one case. It's the portfolio recovery versus Vanessa Grimaldo. CL.
Which one is that one?
CL 153946. It's for a prove up.
Oh, okay. So Vanessa, Venessa Grimaldo. Vanessa Grimaldo. Vanessa Grimaldo. Okay, that is actually at 11. So I do have to give the defendant time to get on at 11.
Okay, I'll come back at 11.
Yes, you can log out and then log back in.
Okay, it's the same.
Yes, it'll be the same one.
Okay, thank you.
Thank you. Okay, Ms. Olivares, Attorney Fela Olivares, what do you have? Attorney Fela Olivares? Ms. Beaver, what case are you here on, Ms. Beaver?
Good morning, Your Honor. On F 4543-21-9, Pedro Mata and Debbie Montes. I believe it's a pro se divorce.
Okay, Ms. Montes, can you hear me?
Yes, ma'am.
Okay, you need to get at a location and stop walking around because you're making us dizzy. So you need to just sit down and find a place. There you go. Okay, Ms. Montes, have you heard from your husband, Pedro Mata?
I talked to him yesterday.
Okay, and was he going to be appearing today?
No,
All right, and did he sign a divorce decree?
I believe so.
All right, but did you all, because the Attorney General's office is making an appearance today, Ms. Beaver, did you all file a intervention, or are we here? Is that your motion to consolidate or whose?
I believe so, that we filed the motion to consolidate this with F 4377-18-2. And we filed an intervention to take judgments, and the period for answering is still ticking. So I would ask the court for a brief reset for that period of time to expire, but we would ask that the court grant the motion for consolidation.
Okay, Ms. Montes, do you understand what the motion to consolidate means?
No.
Okay, so you had a case open with the AG's office in the past. So when you have the child support case open and now you file a divorce, you need to have those two cases together. Okay, so I'm granting the Attorney General's office motion to consolidate. And then now, since they have a motion on file that also requires service, they've served you all and the time is still open or the time's running, then how much time is that, Ms. Beaver? Do you know?
Oh, just a couple weeks.
Okay. We're gonna come back on May the 2nd. That's the earliest I have. And I suggest, Ms. Montes, that you stay in contact with the Attorney General's office because your divorce decree is going to have to show the numbers that Ms. Beaver states are owed. So the decree that you submit has to have the numbers that Ms. Beaver is saying are owed, okay?
Okay.
So I'm not.
Because I have both of the case numbers and I already turned in the form of consolidate or whatever the consolidation forms.
Yes, that's not, this isn't it. In other words, there's arrears, maybe your children were on Medicaid, there's things owed to the state.
Yes.
So those kinds of things need to be taken care of before you come back.
Okay.
All right, so do you have a phone number that you can be contacted at by the AG's office?
It's 956-403-1930.
Okay. So we'll come back on May the 2nd at 9:30 to see if it's been taken care of by that date.
Okay.
All right.
Yes, ma'am.
Okay, Ms. Beaver, do you have any other case?
No other cases, Your Honor. May I be excused?
You certainly may. Ms. Montes, you are excused.
Thank you.
Okay, Mr. Zavala, Domingo Zavala.
Good morning, Your Honor. Stella Olivares, and for Domingo Zavala, he's on. I'm looking for Juan Ramos. He's opposing attorney. I don't see him and he hasn't answered my text.
Yes, I don't see him either and he has not checked in.
Okay.
What, do you know what number you are?
No, Your Honor, but it's the F7635.
22, Judge.
Oh, okay.
Oh, thank you.
So you all are here on a status conference. If
It's a final, Judge.
Oh, okay. You all have reached an agreement?
Yes, we pretty much have. We're gonna pick up the agreed temporary orders, but let me find Mr. Ramos.
Yes.
And
Okay.
I will put up
And
my
who
little
is-
hand when I find him again.
Who is the respondent in this matter?
Michelle Lee Salinas.
Okay, she's also not. Is Michelle Lee Salinas on? I don't see her on.
Your Honor.
Oh, dear.
Go ahead.
Judge, if I may, Judge, it's not Mr. Ramos, it is actually Mr. Juan Flores. This was the case, Judge, if I'm not mistaken, that he had not had any contact with his client back in February, and I'm not sure if this is Miss Lee Sandra. I know that there's an iPhone, Lee Sandra, is that her?
No, I don't
Her
think
name is
so.
Michelle Lee Salinas.
Okay, no. So this case, Judge, Mr. Ramos did announce to the court last hearing in February that he had no contact and that he would probably be filing a motion to withdraw. But I did send him the link and I don't have anything on file regarding that.
Okay, so it's Mr. Flores. It's Juan R.
I don't
Flores.
see any documents or any substitution or
Right.
anything.
He hasn't filed, Mr. Ramos wasn't on this case. It was Juan Flores. So he hasn't filed a motion to withdraw.
Okay, because Juan Ramos was my temporary orders. So he
Really?
must have, yes. Juan Ramos is the counsel on my agreed temporary orders back in November 2020. But I do recall Juan Flores was going to take over, but he never filed anything since February. Let me find him, Judge, if your office could please call Mr. Flores. I don't have a number for him.
I don't have Mr. Flores's number, but is there a number for Juan Flores? So maybe Ms. Olivares' office can contact them?
Yes, Judge, I have 956-970.
I'm sorry?
956-970.
970.
9246.
We'll call him right now, Judge, and I'll come back on.
That's fine. Just be on standby.
I have a 1 at 11, but that's later on.
Okay.
Thank you, Judge.
All right, ma'am, on Lee Sandra's iPhone, what are you here on?
On a finalization of a divorce.
Okay, what's the name?
Lee Sandra Garcia Cuellar versus Ruben Cuellar, and my counsel should be online, Sunny Palacios.
Okay, my notes indicate, I do see that your husband is on. However, my notes indicate that they filed a Rule 11 to pass today's hearing. So you may want to contact your attorney.
I'm sorry, Your Honor. He actually messaged me, my attorney, this morning, giving me the conference line to log in.
Oh, then I don't know, because they contacted us and gave us a Rule 11 saying that they were passing it. I'll give you an opportunity to contact their office and you can be on standby.
Yes, ma'am. Thank you, Your Honor.
Okay, thank you. Who is on Jerry's iPhone? Jerry's iPhone?
Yes, ma'am.
What are you here on?
Gerardo Gonzalez, ma'am.
Oh, okay, you're not till 11, sir.
To 11? Okay, ma'am. All right.
Yes.
All right.
So you
Thank
can
ma'am.
get off and log back in at 11.
At 11. Okay. All right. I didn't know, ma'am. All right. Thank you, Your Honor.
That's fine. Okay,
bye-bye.
Mr. Ray, Mr. Garcia, and Mr. Solis, Mr. Carnohan just has some 6 quick announcements on those like portfolio recovery type cases. Let me take them up and then I'll take you up. It shouldn't be much. Okay, Mr. Carnohan, what do you want to start with?
Let me start with the Tavera case, please, Your Honor.
Okay.
We're asking for a summary judgment on this matter. I believe there's been no response filed to our summary judgment by Mr. Tavera.
Okay, do you know what number that is?
Yes, that's CL 19-2382 -I.
I don't have that on my docket.
Number 26, Your Honor.
Oh, let me see. Oh, okay. CO 192382-I Cons Appliance versus Gelacio GELA CIO Tavera, Gelacio Tavera. Okay, the name being called out 3 times, no response. And what do you want to put on the record, Counselor?
I'd like the court to take judicial notice of the summary judgment having been filed and served upon the defendant, no response being filed by him within the time allowed, which would be at least a week before today's hearing. We'd ask that the court take that into evidence and grant the judgment as prayed and proven in the summary judgment documents.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically that no timely response or a response was filed to plaintiff's motion for summary judgment. Therefore, the court is granting the relief and as prayed for in on the motion.
Thank you, Your Honor.
Okay, next.
And the next one we'd like to take up is the Haro matter. That's Jose Haro. It's TD Auto Finance and it's cause number 0223.
Okay, that's number 8 on the court's docket, CL 190223-I, TD Auto Finance versus Jose Haro, Haro, Jose Haro, Jose Haro. Okay, the name being called out 3 times, no response. Go ahead.
We'd ask that the court grant the default.
Uh-oh. Go ahead, try again.
Thank you. I would ask that the court take judicial notice of its file and note the default judgment documents that were all submitted to the court in advance, the certificate of last known address, the non-military affidavit, the business records affidavit, and grant the default judgment pled and proven by those documents.
Okay. The court is taking judicial notice of all the documents in the court's file, and specifically that the service of return has been on file for the required amount of time. No response has been filed by the defendant, and the relief and prayed for is granted.
Thank you, Your Honor. Next, I'd like to go to the Cerda file, Julie R. Cerda, and that's number 0121. It's an 18.
Number 1 on the court's docket, CL 180121-I, Portfolio Recovery Associates versus Julie R. Cerda, Julie Cerda. Okay, that is set for a dismissal for want of prosecution. Are you asking that that case be retained?
I am indeed, Your Honor, and we ask that the court retain it. We'll ask for a default judgment hearing next.
Okay, go
I
ahead.
believe
and
that
file-
motion's already been filed.
Okay, if it's already been filed, an order resetting or an order setting, the default for that default judgment has to be filed. And I'm gonna go ahead and set a tickler for April the 28th to make sure that it's been filed.
Very good. Thank you, Your Honor.
Judge,
Go
for
ahead,
the-
Ms. Rivera.
This case was set for dismissal of want of prosecution because nobody appeared on that motion for default. So just for clarification, Judge.
Yes, so you need to file an order resetting hearing.
Gotcha. Reset.
Okay. your
I
next
appreciate
case-
that extra detail. Thank you.
All right, your next case?
Let's go to the Garza file. That's 17-4586.
Okay, CL 174586-I, Cons Appliance versus Jose D. Garza. Jose Garza. Okay, we're here on a status conference because defendant had made contact with the attorney. Do you have an update on that?
I do indeed, Your Honor. That matter's been settled. We'd ask that the court just set this aside for 60 days to allow the documents to be exchanged and whatever else is required to wrap up the settlement.
Okay, we'll just set a tickler for June the 30th, just to see if it's been submitted.
Thank you. And then we'll go to the Perez file next.
CL
Mikala.
170560-I, number 10 on the court's docket, Portfolio Recovery Associates versus Mikala, Mikalla Perez. Okay, and what's the status on this matter?
It's the same song, second verse, Your Honor. We've got this one settled too and asked for 60 days.
All right, we'll set a tickler for June the 30th.
Thank you. And that just leaves then the Ureste file.
Okay.
And this is same song, third verse now.
And let me see, what number is that one?
18-4431.
I'm not seeing it. Do y'all see it? What's the defendant's name?
Judge, that was for Monday, Your Honor.
This past Monday?
Yes, ma'am.
Oh, okay, that was on Monday's docket,
Upcoming or the past Monday?
past Monday.
Oh my. Well, let me pull it out of the fire then if I can, please.
Okay, what was the cause number? We'll check to see what happened.
18-4431.
Judge, I believe the court had set it up for DWAP. We don't have a date yet.
Okay. So I'll go, since you're just announcing that it's settled, we'll go ahead and make that notation. And we'll give you the same, it'll be a tickler just for my notes to check on June the 30th.
That's great. Thank you, Your Honor.
Okay, anything else?
That's all I have this morning. Thank you so much.
Okay, you do not have Ruby Mora?
No, I don't. But if that one's
Okay.
on the docket, I'll be happy to keep it from being DWAPed.
Well, it is on the docket for a dismissal for want of prosecution,
Oh,
but I don't know.
I have no idea what the status of it is, Your Honor. They may be
Right.
happy for it to be dismissed, but as a general rule, they don't want them dismissed.
Yes, but, okay. Well, then if we've taken up all your cases, then I'm gonna go ahead and continue with the docket.
If I might get that defendant's name, please, Your Honor, and the
Ruby,
or the-
R-U-B-I, Mora, M-O-R-A.
and if I could trouble you for the cause number, please.
Sure, CL 184836-I.
Got it. Thank you so much.
Okay, thank you. You have a good day.
Thanks, you too.
All right, Ms. Olivares, did you all find out what happened? Mr. Flores is on.
Yes, Your Honor, I just spoke to him. He was gonna get on. You're on.
Okay, you're on mute, Mr. Flores.
Sorry. There we go. On this, I was retained about a year ago on this matter, and I lost track of my client. I can't find her. She lost total contact with me. She basically breached our agreement, right? So I'm gonna have to file a motion to withdraw. I haven't talked to her since the last time I talked to her was in June. So I've lost complete track of this client. I have no idea where she is. So I'm gonna have to file a motion to withdraw. I guess I could just mail it to her at her last known address, right, to satisfy service and file that with the court and move from there, Your Honor, but I can't represent on this.
Okay, well, we had expected that to be done back in February. So, because the parties wanted to, I mean, Mr. Zavala wanted this already concluded. So if you can please get that done as soon as possible, because I'm gonna only give a short reset so that he can finalize this matter.
Okay.
Okay, so Ms.
Wait,
Olivares,
when we come back, or I can, at that point, you can grant the withdrawal and then you can go forward.
well, I believe Ms. Olivares wanted that motion to, I'm not sure if you filed a motion for substitution.
Oh, so it might have to come from Juan Ramos? Let me see. Hold on. I thought I had filed a motion for substitution. Maybe not.
I'm sorry, Judge. She changes her number constantly. I do have a number for her right
Okay.
now that she's currently texting us back to right now.
What's the phone number?
It's gonna be area code 956-274-8752.
That's
Okay.
274-8752.
Yes, and I'm trying to get her to log on right now, but she's responding pretty fast, but she says she's too busy to log on.
Well, I mean, Ms. Olivares can explain to you your remedies. We can take this up without her, just not today. But we
Okay.
can, if she doesn't want to participate in this, that's fine. But Mr. Flores has to be able to send her the motion to withdraw. And then that way we can allow her, if it's done at least today or tomorrow, I can have you all come back in and get this done. I don't want you waiting any longer because you waited the almost 2 months during this time period. So if he can get it out, then I can at least have you back here on April the 27th. That's as fast as I can do it.
Okay.
At 9:30.
What day was that, Your Honor?
April 27th at 9:30, and that should give Mr. Flores enough time to send her the thing by mail.
Okay.
And
I
then,
do have an email for her, so I'll put her email on the bottom of the order. I'll refile.
Okay.
I'll file an order setting here. For
okay.
final.
Go ahead, Mr. Vera.
Judge, for clarification, there is an order on the motion for sub-council, and that was filed and signed last April.
Okay,
Okay, so then yeah, I will be withdrawing as soon as I talk to her. I'll
Last
give her,
April?
yes, I got on the case last April, Ms. Olivares.
2021?
Yes, that's when I got on
Wow.
the case.
Okay.
all right. Okay, well then I'll go ahead and we'll come back on April the 27th at 9:30 and we're gonna proceed with or without her.
Thank you, Your Honor.
Okay,
Thank you, Your Honor.
Have a
All
good
right.
day. I'll be back
Thank
at 11, Judge.
okay,
Thank you.
thank
Thank
you.
you.
Okay, Rosa Martinez.
Sí,
Ms. Castañeda, please ask Ms. Martinez if her husband Miguel Gomez is going to be coming on.
Señora Martínez, ¿su esposo Miguel Gómez también va a estar aquí en la cita?
no, no creo.
I don't think so.
Does he have notice of today's hearing?
Le
No sé.
mandaron-
No, whoever's
Perdón.
telling her something on the side, tell them to stop, Ms. Castañeda, that it's your translation that counts, not whoever's there with
Si
you.
alguien está hablando con usted en un lado, necesita parar, necesita escuchar lo que yo le estoy diciendo.
Está bien.
That's fine.
Okay. Okay, tell her that we're here on a status conference because she wanted a citation by posting.
Estamos aquí para una conferencia, Ms. Martínez, porque usted pidió que sirvieran al Señor el newspaper,
No, by posting like at the courthouse.
que pusieran la noticia ahí en la corte.
Sí.
Yes.
Okay, and did she do it? Because the proof is not on file.
Y lo hizo Ms. Martínez porque no hay prueba de que se ha hecho aquí en su caso.
Sí.
Yes.
Well, then she needs to get that on file.
Necesita poner eso aquí en su caso con los clerks.
¿En dónde, perdón? No entendí.
La prueba de que lo puso de aviso ahí en la corte, esa prueba necesita meterla al caso allí abajo, downstairs, abajo con los que están abajo en la oficina, con los empleados de abajo, en las ventanillas, tiene que llevar la prueba de que estuvo la noticia ahí en la corte.
Yo fui ahí a esa ventanilla y yo pagué un dinero para que lo hicieran.
I went to that window and I paid money for them to do it.
Well, it doesn't matter if she did that, she needs the proof of that.
Okay, necesitamos la prueba de que lo hizo.
Ok. ¿Y la tengo que llevar a dónde?
And where do
¿A
I
esa ventanilla?
to that window?
Yes, she has to file it.
Sí, tiene que llevarla, archivarla ahí en la corte.
Ok. Está bien.
Okay, that's fine.
Okay, then what we'll do is I'm gonna give her another date for June the 1st. Actually, no, June the 27th, because something tells me that it's gonna be more complicated. So June 27th at 9:30.
Le vamos a dar otra cita que es para el 27 de junio a las 9:30 de la mañana.
Está bien.
That's fine.
Okay. All right, tell her that she's excused.
Ya se puede retirar.
Gracias.
Thank you.
All right. Okay, now I think we're ready to get started with your contested issue. All right, I'm going to recall CL 2028-15-I Daisy Reina et al. Versus Antonio Quintanilla. All right, Mr. Solis, announcements have already been made by the attorneys as to who they represent. So we can get straight into your motion, sir.
Your Honor, real quick, I believe Mr. Garcia was gonna address the court.
Yes,
Your
sir,
Honor.
Mr. Garcia, go ahead.
Thank you, Judge. Yes, we have the third-party action with Quintanilla having been resolved, but it's going to require a minor approve-up and the court's approval. But we've gotten that straightened out. We've got an ad litem. We just need to set the matter for hearing. That's what I wanted to discuss with Mr. Solis. Thank you, Judge, for accommodating that interaction with Mr. Solis. So I actually don't have anything further, and if I could be excused, I respectfully ask the court to allow me to leave this hearing.
Okay, so will you be submitting an order setting hearing for that hearing?
That is correct, Judge. I've contacted Ms. Regina Richardson's office a couple of times to make certain that she's aware so that she can have her opportunity to meet with the next friend and the minor. I'll call her again today, and once she confirms that everything is on board, I do ask Mr. Solis to simply send me his drafting instructions so I can request this check, and we'll set the matter for hearing.
Okay, no problem. Yeah, bless you.
Thank you.
Go ahead and have your excuse, and you have a great day.
Thank you, Judge. You as well. Mr. Solis, Mr. Ray, good to see both of you. Y'all take care.
Okay.
Bless you, Barry.
Thank you, sorry.
It's allergies. You should have seen me yesterday. It was horrible. Okay, so then we only have what's pending is with Mr. Ray on the other side?
Yes.
Correct, Your Honor.
Okay, so go ahead and do you want to address your
Sure.
concern?
I think it'd be easier if we go one by one where we argue one and then you rule. So that's how I'd like to proceed, but I'll defer to the court.
That's fine, whatever's efficient.
Okay, so with regards to the first interrogatory, I'm requesting identifying information of the corporate representative for State Farm, namely the adjuster assigned to the case. I believe that's who it is. The only thing that was provided is the name. It does not provide date of birth, driver's license information, job title, how long he has been with State Farm. And the reason why that's important, Your Honor, is because I need to verify whether the adjuster has a criminal history. If the adjuster is getting deposed, I'd like to know that information, that I am talking to the right person. Opposing counsel on every case, not just Mr. Ray, always wants identifying information of the witnesses to confirm who they are, find out if there's a criminal history, since they're going to be providing testimony, so you can address the veracity and truthfulness of what they're saying. And I'm wanting the exact same thing. They are listed as a witness. They have been disclosed. It is the corporate rep, and I need to know more than just the name of who this individual is. I'm not asking for social security numbers. I'm not even asking for home addresses. I just want to know the name, the date of birth, and how long this person has been employed with State Farm, and the length of time of their employment.
Okay, Mr. Ray?
Good morning, Your Honor. Let me just first state that, this is a simple car accident case, really. The plaintiffs have already collected settlement money from the other driver's liability carrier, which is represented by Mr. Garcia. In this case against State Farm, the only issue in this case is the nature and extent of the plaintiff's damages and whether they're entitled to underinsured motorist benefits. That's the only issue in this case. With that, I will say, with respect to interrogatory number one, all he asked for was the name, age, date of birth, which is basically the same thing, length of employment, and current job title. What we did provide was the name, Tad Mora, and his job title as claim team manager for State Farm. We did object to providing the other information. We just don't think that's relevant at all to providing, sworn answers to interrogatories. He's not, it's different than if it's the plaintiff when you're investigating what their claims are. He's just swearing to the truthfulness of the answers to interrogatories. So we don't think the date of birth or length of employment is relevant. So that's why. we
Okay,
object to
so
that.
hold on, let me tell you, because I read your motion. So the date of birth is not relevant. Okay, length of employment is relevant. And I'm gonna tell you, everything that I read on these, they're not unreasonable. Why can't you all come up with an agreement? It's not unreasonable at all. As a matter of fact, in everything that I'm reading, it's pretty standard, and they're not asking for any personal information on the person that's reviewing the claim or the corporate representative. Now, personal information on the corporate representative, I am not going to allow ever, because I don't think you need to know anything personally about them. Only what their relationship is with their employer. How long they've been there, well, that is relevant, because you want to know if you're getting a person that is experienced or not experienced. You do need to know whether or not the defendant, how long has the defendant been insured with the plaintiff? That's easy. Just submit the policy, and you can also give a letter stating, I mean, I used to get them all the time, like, how long did they have a policy with that insurance company? I mean, it is necessary to know the number of claims. Is this person a habitual person that continues to get into car accidents? I mean, I don't know why that would be difficult to be letting them know. Now, regarding premium payments and the length of times payments have been made, I mean, it doesn't matter how much they're paying for the policy. You just really want to know the policy, but I don't think it's a big deal to know what the premium payments are and how long he's been paying those payments. I don't think it's a big deal. Any payments for the claim, you need to also, I don't think that's anything. I mean, to be honest with you, anything in here is not unreasonable, with the exception of 10 years. Don't do that. Like, I mean, be reasonable with the amount of time period. All correspondence from the defendant to the insurance regarding lapse of coverage for the previous 10 years, that's unnecessary. That's a little extensive. So narrow that down either to around the time when the accident occurred or a little bit beforehand. I mean, I don't even know if you need to go, for sure, not even further than 5. So, and if you want, I mean, really, you're probably looking at maybe 3, but I'm going to give you all an opportunity to discuss how many years, but it won't be 10. And then electronic data from the claim, nothing's privileged. So that needs to also be given to the plaintiff. The claim file for this claim, if it's privileged information, which that I'm aware of, it's not, don't give it. If it's not privileged, then give it. It's just the basic, rules of discovery. Documents which support the date the defendant anticipated litigation, well, that's speculation. I mean, you don't know when they were going to anticipate litigation. So I'm not sure that they'd even have anything to show for something like that. But everything else that I see, I mean, we're not going to go through this one by one because it's unreasonable to me. I'm going to give you all a general order, which is that, State Farm is ordered to answer what is outlined here. And they're going to be compelled to do that within the next 45 days. With the exception, like I said, no personal information on the corporate representative, and it's not going to be 10 years. You all decide what it is that you want.
Your Honor, if I may, with regards to the time limit, I think a fair time limit would be the same time limit as defense attorneys usually get when they want to get past medical records. I think 3 years or 5 years is what it's been capped at in the past with this court. So I'd request 5 years as opposed to 10, but it should be analogous to the amount of time that defense counsel wants to go back and obtain medical records on any given case.
Okay, go ahead, Mr. Ray.
Well, I just wanted to say, Judge, that since he filed his motion, we have produced the claim file. However, we redacted information out of there after we did anticipate litigation, which was, after we received the letter from Mr. Solis, like a week after the accident or whatever the date was. That's when we anticipated litigation, because that's when he told us that he was going to be pursuing those benefits. So all of that has been produced. Now, again, I understand your ruling, Judge, but let me just say, this is just a regular car accident case. This isn't a case where they're seeking a bad faith claim or DTPA or Texas Insurance Code violations. So, you know, a lot of that information they're asking for as far as premiums paid, whether there's been a lapse of coverage, there's no coverage dispute. None of that is involved in this case. So the only issue is the plaintiff's damages. So, you know, and also the premiums paid in the past, I mean, that's going to be available to them. I mean, it's his client, so they should have that information. So other claims that have been made by them, what relevance does that have to this case? How is that going to be admissible and relevant in this case to the damages?
Your Honor,
that might be relevant in a bad faith case, extra contractual case, but none of that stuff they're asking for is relevant in this case. It's simply not.
if I may, Judge, again, this is discovery. What's admissible in court is a different standard. We're not before the jury right now. We're not presenting the case to anybody. This is discovery. We're trying to find information out. So the fact that they're saying it's not admissible might be the case right now, but it doesn't mean it's not discoverable. Also, with regards to anticipation of litigation, the reason why that's important is because the claim file is protected up until the date anticipation was litigated. The fact that I sent the letter to State Farm saying we're going to present a claim doesn't mean that the case is suit's going to be filed. The numerous cases always get settled before pre-litigation. So if that's the reason why I wanted documents to support when they anticipated litigation, because that's going to determine what portions of the claim file I'm entitled to. And again, merely filing a letter of representation is, in my opinion, not sufficient. Maybe once they send me a letter where they're rejecting my demand, then they know the next step from there is filing suit. I think that's when litigation should be anticipated. But the mere fact that I'm filing a letter of representation, that should not be the basis for litigation being anticipated. If that's the case, I'm being sent two messages that they're never ever going to settle with me because it's me. And when they see my name on the letter, they know that I'm going to have to file suit because they're not going to ever offer enough. Or the other assumption that can be made is anytime any attorney sends a letter, they're going to anticipate litigation. But of course, both those are not accurate because I've settled numerous cases with State Farm prior to litigation, as have other attorneys. So that's why when anticipation is litigated is important, because it determines at what point the work product begins and at what point the claim file is no longer discoverable. One more thing, Judge, with regards to the claim file, Mr. Ray did give me the claim file, but the number of information that was redacted is huge. They're redacting information about my clients, like my client's date of birth, my clients' names. Again, Judge, they're redacting information that maybe the jury should not see, but this is not in front of a jury. This is discovery. It's not what's admissible. If you'll allow me to share the screen, I'll show you the portions of the claim file to illustrate why I believe they shouldn't have redacted everything that they redacted.
Well, I think that, I mean, they still owe a duty to your client, even though, I mean, he's their client and I mean, he's their customer. And I think it's just, I don't think it's unreasonable, even if they took out your client's personal information.
They took out information that's in the police report, like the name of the other individuals in this accident. Why does that need to be redacted?
But don't you have the actual police report?
I do, Judge, but
that's unredacted.
Well, it's not just the police report. I want to know everything that's being redacted. Personal information is irrelevant at this point in time because it's not being presented before a jury. I should get to know the names of people involved because it might lead me to other potential witnesses. And they're redacting it under personal information. And Your Honor, that's why I'd like to show the court.
Just on the police report, Your Honor, we're redacting personal identifying information of other individuals on the police report, but don't have to do with this case. And his clients, by the way, were minors. And so that's another reason why we did that. So again, all that information is on the police report that he has. We're just redacting it out of the claim file when we produce it. So
It doesn't need to be redacted, Judge. It's too early. It's not like it's before the jury's eyes.
I think that, I mean, look at the information that you have. I mean, isn't there another source that you can get that? I mean, I think it's just their policy. I mean, it's not, they're not the first ones to do it on your case. It's not because it's you. But do you, don't you have another manner to get, I mean, you're entitled to the police report.
No,
You're
I
gonna get
have
the police report, and that police report has everything in there that you're going to need anyway. You know what I mean? So why does it matter if it's unredacted? I mean, that he redacted it or not?
Because maybe whenever they're speaking with their, maybe whenever they did their own investigation, they found out additional information that I don't know if it's been redacted or not. Maybe there's
Hold
other
on.
information.
Mr. Ray, are you local or are you out of town?
no, I'm in Harlingen, Your Honor.
Okay, so
Yeah.
we're not gonna be doing this back and forth thing. This is why I'm gonna start doing all my contested hearings in person, because
Oh,
I feel
okay.
like I need to just talk to people in person.
Hey,
about
I would
certain-
love that, Your Honor.
You
I'm
know,
tired of being in
certain
my
things.
office.
So this is what we're gonna do. I mean, you already know where I'm going with this, so I'm gonna have, we're gonna do a conference, okay? We're gonna do a conference just with us, in chamber conference. Look at your
Okay.
schedules, and
Okay.
it's gonna be, I'm gonna talk to my court coordinator to contact you all so that we can set it up. Look at your schedules. If tomorrow's too soon, that's fine. Let me know, because I'm in person tomorrow, so I'll be at the courthouse. But if not, I mean, I'm gonna see you all very, very soon, because we're gonna talk about this, okay?
That's fine, Your Honor. Yeah,
Um,
tomorrow is too soon. I have a deposition and a hearing tomorrow and a
that's
possible
fine.
trial next week, so it needs to be.
Okay, but we're gonna set up a time to come in, okay? But you all already
Okay.
kind of know where I'm going with this. You can start working on the information between now and the time we meet, but we will be meeting about this. I'll have Ms. Rivera or Ms. Castañeda reach out to you all to set up a time for you all to come in, and we'll just chat, okay?
All right, Your Honor.
That's a great idea.
We'll see if we can work it out.
Okay, all right, we'll see you all soon, okay? You're
Thank you.
temporarily excused.
Your Honor,
Till
real
next-
quick, if I may, we were also here for a status hearing. Obviously, you can tell that this is, we've gone to mediation. This has not been resolved. Can we get a DCC date?
Not, you will, okay?
Okay.
Let's talk first.
Okay,
Okay.
last thing, Your Honor. I showed that there was a hearing on my MSJ on 11/17/2021. My notes show that the MSJ was granted, but I have not received the order unless my notes are incorrect and it was not granted, but I'd like to get that signed order if it was.
Okay, I'll have Ms. Rivera pull it, and I'll review it to make sure.
With that, Judge, I don't have anything else, believe it or not.
I was like, you sure? Okay. All right, y'all have a good day. I'll see you all soon, okay?
Thank you, Your Honor.
Judge.
All right, take care. Mr. Palacios, what do you have, sir?
Good morning, Judge. I have number 4 on your civil docket.
F 4702-17-9 in the matter of the marriage of Lee Garcia Cuellar versus Ruben Cuellar.
Good morning, Judge. Sonny Palacios with Ms. Cuellar, Judge. If you can recall, the last time we were proving this matter up, and there was some discussion regarding some previous cases. And the court would like ask us to look into the cases and possibly consolidate it, whichever ones are active and not active. After a lot of research, Judge, we did find a case in County Court 8, this one County Court 9. We did find another one in County Court 6, and then we found one in Child Welfare Court. We have a filed notice of appearance of counsel on all cases, so that way we can retrieve all the information, see which orders are valid, which orders are no longer valid, and then so we can consolidate appropriately.
Okay.
Back into this court.
Now,
If I can
is-
have maybe 3 weeks, Judge?
Is Mr. Cuellar still being represented by Martha Garza?
He is no longer judge. She withdrew on the previous court date.
Okay, Mr. Cuellar, will you be retaining counsel, or are you continuing to represent yourself?
I'll be representing myself, ma'am.
Okay, so just so you understand, in other words, you and Mrs. Cuellar have had several issues, it seems to me, with respect to your children.
Yes, ma'am.
So this means that there's been cases that have been opened and they've fallen in different courts. And in order for Mr. Palacios to even be able to get information, first he had to research, because when the system, when it comes to children, especially in child welfare court, that information is not public. So we can't get that information if you are not the attorney of record. So he filed notice of appearances, in other words, that he's representing Ms. Cuellar in this matter in all the cases. It doesn't mean that those cases are open and going to continue, but it just means that that's the only way he's going to be able to see the files. So now that he's going to see the files, then now he's going to file a motion to consolidate. And in that motion to consolidate will be all the outstanding case numbers, and they're all going to be put into the divorce. Once he does that, which will take about 30 to 45 days, then once he does that, then we're going to get started here for the divorce, because that means now I have jurisdiction of the entire matter. Okay?
Yes,
I
ma'am.
know that's a little much, but I just
No.
need you to understand the process.
I understand.
Okay. So we'll go ahead and come back. We'll come back for hopefully you can get it done by May the 4th at
Yes,
9:30. If you do file your motion to consolidate, go ahead and put your order setting hearing for May 4th at 9:30.
We'll do so, Judge.
Okay, and then we'll get started on the divorce.
Thank you, Judge.
Okay,
Judge,
anything else?
when on that new matter, or when we restart on the divorce, are we gonna adopt all the previous questions, or you just gonna start the whole process over again?
No, we need to
approve it up
see
again?
what's still, we're gonna look at all the orders. Once you give me the case numbers, we're gonna need to see which orders are still valid and active, because you know how it depends. If they have the same content as the other orders, then it carries over, right?
Correct.
But if it doesn't address it, if it has the same, if it deals with the same issue, that's what I mean. Then
Yes,
it's
Judge.
possible an order will supersede the previous order, or it stays the same, right? So if it doesn't have anything to do with any of it, then it's technically a new order on that issue.
Yes, Your Honor. We'll do our due diligence and delineate which are already been covered on previous cases and which are now defunct orders and things like that.
Yeah, exactly. But you know me, I like to read all that stuff.
Yes, Judge.
Okay, so
Thank
we'll
you,
get
Judge.
we'll get it figured out. Okay?
Thank you, Judge. Thank you,
All
Judge. I
right.
have nothing further before this honorable court. May be excused.
Yes, we'll see you on May 4th at 9:30.
Have a wonderful day, Judge.
Thank you. Okay, Ms. Gonzalez.
Hi, Judge.
Hi, what do you have?
Some yogurt. You want some?
Yeah, I do actually.
You caught me as I was like eating. I have Coral Garza and Greg Gallegos, F11 16-22-9.
Oh, okay. Ms. Olivares is already present.
Perfect.
Yes, Your Honor, that's with me.
Okay, and do y'all have an agreement as to temporary orders?
We
No,
do not,
Your
Judge.
Honor,
I just got
we have not conferred, sorry, Ms. Gonzalez, but maybe if you put us in one of those little rooms, the breakout rooms, me and Ms. Gonzalez and her client, my client's present with me, we can talk.
Okay, that's fine with me. I don't think your client has connected to audio if you have him at your
He's
office.
actually right here in my office, Judge. I was just gonna have him on a separate screen. So let me just get that set up while you send us over to the breakout room, and hopefully we can get it worked out.
What is your picture? I see Miss Savannah on a picture, then I see her in person.
Because the gentleman is on another computer. And so she's gonna set him up over there. See? There, she's in double screen right there.
There she is.
But you should be able to have you should have the invitation in front of you.
Okay, we're joining in, Judge. We'll be back.
All right, good luck.
Thank you. Mhm.
Okay, Miss Max Vasquez, we have about 7 minutes, so we're gonna just take a quick break. I can't take you up till 11 since the docket says 11.
Okay, no problem.
All right? Okay, we'll be off the record until then.
Okay, thanks.
Okay, Ms. Flores? Are you ready?
Yes, Judge, ready.
All right, we are back on the record, and let me take you up, Miss Max Vasquez. What number, ma'am? Oh, you're on mute.
25.
I'm sorry.
Okay, number 25, CL 153946-I, Portfolio Recovery Associates versus Vanessa, Venessa Grimaldo, Vanessa Grimaldo. Okay, Ms. Grimaldo's name has been called out 3 times and no response. Go ahead, you may proceed.
Yes, Your Honor, we're here this morning for a prove up on a default judgment. The issue on the last hearing was inefficient service, so we remedied that, and we are now here asking for a judgment. Today, we ask the court to take judicial notice of all documents in the court's files to include the exhibits, the statement of account, Department of Defense report, certificate of last known address, and the actual final judgment motion asking for the actual damages in the amount of $3,797.13. It also includes court costs totaling $362.17. That does include the suit and filing fees and the service of process for $80. And so that's what we're asking for today.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file for the required amount of time, and no answer has been filed to date by the defendant or on behalf of the defendant. So the court is granting the relief as requested and put on the record and set forth in an order that, let me see, has been on file since June 23rd, 2017. I'll ask for that one to be forwarded to my queue.
Okay, thank you, Your Honor.
Anything else?
That's all I have today.
Okay, thank you.
Thank you so much. Can I be excused?
You certainly may. Take care.
Thank you.
Okay, Mr. Ramirez, are we ready to move forward on your hearing after all?
Good morning, Judge. Daniel Ramirez for the record. Is this cause number F474129? I'm sorry, Judge, I do not have the docket number.
Okay, it's number 23 in the court's docket in the matter of the marriage of Melissa, Melissa Gonzalez, Gonzalez, versus Gerardo Gonzalez.
Yes, and I represent Melissa Gonzalez, a petitioner.
Okay, Mr. Gonzalez is present. Mr. Gonzalez, are you still representing yourself, sir?
I would like to go ahead and retain an attorney, ma'am.
Okay, and how long have you known that? Like, why haven't you done it since the last time?
I already talked to one of the attorneys, and we're in the process to go ahead and retain them, ma'am. The visit, because of the visits and stuff like that, ma'am, I don't agree. On Saturday, we went to Chuck E. Cheese. It was moved to Chuck E. Cheese. We agreed, me and her and the attorney, we agreed to move it to Chuck E. Cheese. And, well, I'm trying to be civilized as much as I can. She was late 20 minutes and I didn't file a report or anything like that. And then the visit, we cut it short. And on the next day, we had agreed to meet up at Whataburger at 12:30. And I got there at 12:32 and she filed a report on me. So I think I didn't get to go ahead and take them to how we planned because I'm not gonna be putting up. Now,
Okay, hold on. I get it. I can see where this is going. I did this for 20 years, so hold on. I'm gonna tell you right now, Ms. Gonzalez, Mr. Gonzalez, and Mr. Ramirez can tell you, I don't play these games. These things about reports on each other for 5 minutes, even 10 minutes, that's ridiculous. Because all you're doing is you're exposing your children to police and you don't have to do that. So I'm gonna tell both of you that you all are adults. So if you're adults that you expect for me to trust you with your own children, then you need to act like adults. I don't care if you don't like him or you don't like her as a person. You all have children together. So don't play those games anymore because I won't tolerate it. So
Your
Mr. Gonzalez, that's fine. You can hire an attorney. I can't take that right away from you, but we are going to have a status hearing on May the 4th at 9:30. And by that date, he needs to have retained that attorney so that you all can move forward.
Your Honor, may I say something?
Sure.
Yes, Judge. On Saturday, and Ms. Gonzalez, correct me if I'm wrong, you indicated that Mr. Gonzalez decided to cut the visit short because he was sleepy. He's the one that didn't want to continue with the full amount of the visitation time that he was afforded. And on Sunday, you thought the agreement was that you were going to be meeting at Whataburger at 12 noon, and it was not until 12:30 or 12:25, you remind me, that you decided to make an information report because you had already given him a lot of time to show up and he hadn't. And Judge, is that correct, Ms. Gonzalez?
Yes, that is correct. And can I please elaborate a little bit on Saturday?
No,
Saturday?
because honestly, it's only your attorney. You're represented by counsel, so he's the one that's elaborating. Okay. And this is all going to be either in a hearing or something, so I don't need to hear it twice. So don't worry about that. You'll get to tell your side of the story. So don't worry about that. So what we're going to do is give Mr. Gonzalez the opportunity to go ahead and hire an attorney. We're going to have a status hearing on May the 4th. Mr. Gonzalez, you better have your attorney by that date. All I wanted to let both of you know is that I just don't play games. That's it. So I'm sure there's always going to be two sides to a story. I'm not saying that that's what you did, Ms. Gonzalez, not at all. And I'm not saying that, Mr. Gonzalez did or did not say those things, not at all. I'm not taking anything that either one of you is saying as true, and I'm not saying that it's not true. All I'm saying is that I need for you all to know that this court doesn't play those games. That's it. So just act within those parameters. So we'll go ahead and come back on May the 4th at 9:30 for a status, and then get your attorney as soon as possible so that perhaps you all can enter into temporary orders if you can't do final, and if you can, so that you can go to a mediator if possible.
Judge, just as part of the history, Judge, Mr. Gonzalez had hired counsel, but his attorney withdrew because there was lack of adequate communication with Mr. Gonzalez. This case has been reset. It's been pending on the court's docket for a long time, and it's no fault to Miss Gonzalez. She wants to get her divorce. She filed pro se, and she hired me to see if I could get it done. And so if by the status hearing, Mr. Gonzalez does not have a lawyer, Judge, we really need to proceed as soon as possible to have a final hearing on it.
Yes, I agree. So that's why he has to have somebody by May the 4th. So if you don't, Mr. Gonzalez, then you need to be prepared to move forward on your own.
Yes, Your Honor. Can I say something? I already, I'm on the process right now, ma'am. I already, as of today, they're gonna do the paperwork and everything. We were just waiting for me to go ahead and let you know that I was gonna get an attorney. Oscar Rene Flores is gonna be representing me, ma'am. So, I will be hiring him. As soon as he gets everything, he'll go ahead and send the paperwork to the court.
Okay. All right. So your status is May the 4th at 9:30.
Yes, ma'am.
Okay. Y'all are excused.
Okay. Thank you, ma'am.
Okay. Good morning, Mr. McLaughlin. What do you have, sir?
Your Honor, I have number 24 on your docket, Jefferson Capital Systems versus Edna Munoz,
Okay.
CL
CL
20-2833.
All right. Edna Munoz. Okay, that name being called out 3 times and no one in the waiting room. You may proceed.
In this case, Your Honor, we believe that the defendant had entered into a motor vehicle retail installment contract on January 3rd of 2015. They made their last payment on June 1st of 2017. The account was closed and charged off, and the vehicle was repossessed and sold at auction with a deficiency of $10,118.88. We're seeking that amount in damages plus costs of the court, and would ask the court to take notice of the business records, non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file for the required amount of time. And no response has been, oh, I'm sorry. So I'm not sure, are you aware, Mr. McLaughlin, that she filed an answer on July 29th, 2020?
No, I was not, Your Honor.
Okay. She filed a pro se answer on it's been on file with the court since July 29th, 2020. So you would, I'm assuming you may want to ask if
we can have a bench trial,
well, actually, you're set for a bench trial today.
then
So your proof up would just be different. Your proof up questions would just be different.
So, all right, I'd like to proceed with a prove up at a bench trial.
Okay,
right
so Edna Munoz's name was called out 3 times. Ms. Munoz did file an answer on July 29, 2020. She also was given notice of the setting at 6209 South Galaxy Drive in FAR 78577. And it stated that there was a bench trial set for today at 11 a.m. and no one is here on her behalf, nor is the defendant here. Okay, you may proceed.
In this case, Your Honor, again, we believe that she had entered into a motor vehicle retail installment contract to purchase a 2011 Chevy Aveo. She did so on January 3rd of 2015. She made her last payment on June 1st of 2017. The vehicle was subsequently repossessed. There was a deficiency of $10,118.88. We're seeking that amount in damages. We'd ask the court to take notice of the business records and also the non-military declaration and issue judgment for the plaintiff.
Okay. So being that defendant did not show for the bench trial, the court will make and the evidence that has been presented by the plaintiff, the court is making a finding in favor of the plaintiff and granting the relief as requested and prayed for.
Thank you. Thank you, Your Honor.
Okay, anything else?
No, Your Honor, that's it for today.
All right. Okay.
I appreciate that. I just want to let you know that I appreciate, I was told that this one was at 11 and that I know that you usually start at 9:30 and I really appreciate that doing the default judgment at the end.
Okay, you're very welcome.
Thank you, Your Honor.
Thank you. We're
You
trying.
have a good day.
We're trying. Okay, take care.
You too.
Okay, so while they're still conferring on number 14, did it settled at mediation, so they just need to set a tickler for the documents? Perfect. Okay. And we're on this case, so.
The only one that
Number 2 is the only one that nobody made an announcement on.
Correct, Judge.
Okay, and we're currently, they're in the breakout room on number 27. Okay. Well, then I will notify you all when they come back in then. I'm gonna let them confer. Okay, we're on a break.
Are we the last ones, Judge?
You certainly are.
Oh, well, we have something for you.
Yay.
An
Okay.
agreement.
Super contested. We need 4 hours of your time. Just kidding.
Then I'd be like, come in the afternoon in person. Okay, we'll go ahead and get, let me have, all right, Ms. Flores, we're on the record. We're gonna recall F 1116-22-9 in the matter of the marriage of Coral, C-O-R-A-L, Garza versus Gregorio Gallegos, Gallegos. And counselors, what is the announcement?
Judge Savannah Gonzalez from Mr. Gallegos, happy to report that we have reached a resolution for all matters as to temporary orders. If you'll allow me to read that into the record, and then we can get that proved up by the parties.
Hold on.
Oh,
And that's, yes, hold on. That's correct, Your Honor. And just for the record, I represent Coral Garza, and we do have an agreement. I'll let Ms. Savannah read it into the record. If something's missing, I'll add it.
Okay, Ms. Garza and Mr. Gallegos, can I please have you raise your right hand? Do you swear that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God? Ms. Garza, yes or no?
Yes.
You need to just speak louder, ma'am. And Mr. Gallegos, yes or no?
Yes.
Okay, you may lower your hands. Go ahead, Ms. Gonzalez, you can read it into the record.
Yes, ma'am. Judge, there are 3 children under the age of 18 or who have otherwise not emancipated. At this time, the parties will both be named joint managing conservators over all 3 children. There will be no primary designation at this time. However, by agreement, the children will reside within Hidalgo County. Neither party is ordered to pay child support at this time. Current health insurance and dental insurance to remain in effect for all parties, including petitioner and respondent. Any travel outside of the county with the children shall be via notice to the other party. There's no need to consent, just allow some notification before they travel, Judge. Visitation, there will be no formal visitation at this time since the parties will share the marital residence. At this time, mother will remain in the primary residence and father will reside in the guest house that is separate and apart. The children are allowed to go back and forth between the parties and neither shall hide or secret them. At this time, by agreement, all payments, including the running of the business, shall remain as is. So we're maintaining status quo. And if either party is to draw over $1,000 from any checking or savings account, it must be done by consent. The parties agreed to send notice to their attorneys, and then the attorneys will exchange respectively before that draw is done. There is an additional contract for the purchase of a residential lot on Acacia Street. That's ACACIA. that will be closing within the next couple of weeks. By agreement, that closing will proceed. The parties further agreed to exchange mutual inventories within 30 days. They'll also exchange discovery. And once discovery has been tendered to opposing parties, we will set up an informal mediation via Zoom. If we are not able to resolve that, we agreed to attend formal mediation as soon as practical. And we're requesting, Judge, that you set us sometime after May 18th for final hearing. At this point, we should be able to have all of our discovery and inventories done by then so that we can finalize this in late May. I believe that is the agreement in its totality, Judge. Oh, I'm sorry. And we also have, by agreement, a mutual and joint restraining order. No disparaging remarks, no discussing the litigation with the children, no disturbing the peace, the standard 14 points, Judge.
Yes, Your Honor, and just to add also that we have an agreement, a restraining order that neither party is to sell assets, any kinds of assets, or purchase any, unless they both agree or the court orders that it can be done. And there is one thing that we didn't touch. Mr. Gallegos used to have a salary of before, was it 700?
I think, yeah, 600.
$600, and the last month he's been taking 2,000 a week. So if he takes 2,000 a week, then mom has to match it. Is that okay with you, Ms. Savannah?
Okay.
Well, this is
that's
news to me.
something
Yeah.
should have been discussed while you
I
all
know,
were in
I know.
session.
Well, then he can go back to his $600. Es que they both own a daycare, Judge. And it's salary. He changed his salary himself. I mean, I don't see what's wrong. If he takes 2,000 a week, but she does the same thing. She runs the whole business.
Okay, so this is what, hold on. So usually when it's businesses, and it's been my experience, you either decide what both of you will be getting as a set salary. So whatever is good for one is, I'm not gonna say go back to 600. I'm not gonna say if you do two, or take 2,000 a week or whatever. I'm not gonna do any of that stuff. What I'm gonna do is whatever salary you all decide, then it does have to match the other person because it's 50% and 50%. It's just like partners.
Right. That's good, Your Honor.
I don't know. I mean, Ms. Gonzalez can explain it to you, Mr. Gallegos, and Ms. Olivares will explain it to Ms. Garza, but I'm not going to set that amount.
Okay,
if you all
we'll
need
do-
to come back, I do have I can make room for you all, and then we can discuss that. But you guys did so incredible on this other. I'm sure you all can come up with an amount that you can both live with. Because remember, right now, the whole point, when you're in this process, just to let you know, Ms. Garza and Mr. Gallegos, and I'm sure your attorney may have told you, when you're in this process, we're pretty much just maintaining status quo. We're not trying to get more money so that you can build a bigger nest egg than the other person, because it doesn't matter. You all are still married. Everything is 50-50 regardless. So it doesn't mean if one gets more than the other, they're going to create this nest egg and it's their separate property. No, not at all. So you just want to be able to live right now. The first thing is, of course, you take care of your children, what their needs are, then you take care of the community debts, then you do, and then your community assets. If there's any improvements, you have to agree to it. So there's no hiding anymore. Like at this point, it's just to live pretty much. And so you all think about, what your expenses are, what you've agreed to pay, what you've agreed to pay. So you guys come up with something. Now be reasonable too. Because if you all have agreed that one takes more debt than the other at this point to pay, well, they may need some more substance of money to pay those bills. However, what I used to do, and I'm not telling you to do it, is like, for example, if they had, let's just say that one person gets $8,000, they've agreed to an $8,000 draw, and that's because they have $7,000 in bills that they have to pay. So they're really only staying with $1,000 for the month or something. Then even if the other person only has 4,000 in bills, they would only get a $5,000 draw because their disposable income would
Right.
only be 1,000 like the other person. That's just a thought. That's what I used to do. That was
Yeah.
fair because you all know what you've agreed to do as far as like what bills one's gonna take, what bills the other's gonna take. And you all are in a very unique situation where one is in the guest house, one is in the main house. And that's great because your kids are gonna feel comforted and they can go back and forth and you're really not disturbing them. Obviously, you all know, do not, I'm sure this is in the injunction, do not be bringing unrelated, significant others over or anything like that. And of course, any relationships are discouraged. That's not against the law. I'm not telling you any of those things. I'm just saying that right now you've managed to show me that your children are first priority to both of you. Just in this agreement, both of your attorneys have had me on the other side as opposing counsel. I practiced in the same area they're in for almost 20 years. So they know exactly how I think. Very common sense, very children-centered. That's just it. I don't believe in one is better than the other. I don't care if you all don't like each other or don't get along. I just care if you're good to your kids. That's it. That's all I care about. So I'm going to give you all, I've given you some guidelines. So right now what we're going to do is we're just going to ask both parties if that's their understanding of the agreement thus far, and if they want it. And then that one piece, I'm going to let you guys continue to talk about it to see. Yes, ma'am.
Judge, I have a suggestion and Ms. Garza agreed to it. They can do a salary match because actually she doesn't take anything because she pays all the bills. And you were right in how you explained to us, but it's his too. I mean, I'm not saying that it's not yours, Mr. Garza. Please don't misunderstand me. And so if they do a salary match, if he takes 2,000, well, 2,000, she takes 2,000. If he takes 1,000, well, they do 1,000. So if we say salary match, do you think that's okay, Savannah? If I may address you?
I'm not gonna, I don't think I'm not saying, I don't feel comfortable you all putting each other on the spot right now because I think both of you need to discuss the options with your clients.
Right.
You know
Sorry.
what
And
I mean?
I thought we had left the breakout room with everything. This is the first time hearing
Right.
about it.
And
Judge,
it's fine. Sometimes things come up, but I'm gonna leave that one thing. If you need me, you all know that you can call us and we'll get you set right away. But I know that if you all came up with all of this, I know that you all will be able to come up with that one thing.
We will,
know
Your
it.
Honor. It was the big change in salary that I had forgotten.
Hey, the way you all know the way I see it, and Ms. Garza and Mr. Gallegos, look, I am very aware that divorce is about to change your life. I am very aware that both of you probably feel like your life is turning upside down. I am very aware that what you were used to, as far as being under one roof, and as far as just natural things that husband and wives do, as far as, bank accounts go, like go pulse out, go do this, here's some cash. I'm very aware that all that's about to change. And it's a big change for both of you. I get it. On top of the emotions of ending this marriage that has, how long have y'all been married?
20 years.
20 years.
20 years. And you've built obviously a business together, which do not put the name of the business on the record because we're on YouTube Live, okay? You've built a business together, you've built a life together, you've built a family together, you have built memories together. And for you to be at this point, I am very aware that it is difficult for any couple to decide that it's time to get a divorce. So whatever has brought you here, you're here. So just know that I am very empathetic and very aware of what it takes to be in your shoes. Not because I've been through a divorce, no, but because I've been in your attorney's shoes counseling clients such as yourselves. This isn't an easy decision to make, but the fact that you're putting your kids first, that's amazing, because you'd be surprised how many people we see in our careers that it's all about everything else but the children. And it's going to take some pride swallowing, and it's going to take some concessions of, okay, yeah, you're right. And it's going to take some I'm sorry's, and it's going to take some each taking blame for whatever. It's part of healing. It's part of this journey. Okay, so I get it. So I know that you guys have done an incredible job to be able to go into a breakout room virtually and come up with this agreement. I have all the faith that you all are going to come up with an agreement with respect to this. Okay.
Yes,
So,
ma'am.
all right. So let me just ask, Ms. Garza, you heard the agreement as read onto the record by Ms. Gonzalez, and also the additions with respect to a mutual injunction by your attorney. Is that your agreement?
Yes,
Okay, and are you asking the court to approve that agreement?
yes,
Okay, Mr. Gallegos, you heard the agreement as read into the record by Ms. Gonzalez and the additions by Ms. Olivares. Is that your agreement?
Yes,
And are you asking this court to approve that agreement?
yes,
Okay, now, Ms. Garza, do you believe that this agreement is in the best interest of your children as far as visitation, possession, and access?
yes,
And Mr. Gallegos, do you believe that it is in the best interest of your children?
yes.
Okay, so the court is going to approve the agreement as read and testified to on the record by the parties. The only issue that will be pending is what to decide what the salary draw will be. And I will allow you all to go ahead and talk with one another once we get off, or whenever you all decide on doing this. Your final hearing will be on June the 1st at 11 a.m. So that's a date to work to. If by some chance the 60 days has passed and you all have come to an agreement sooner than that, I will be happy to accommodate you.
Yes, Judge.
Okay?
Yes.
All right. All right. Best wishes to both of you, and hope to see you, when we finalize it, but I'm here to serve you in case you have some other issues that come up in the meantime.
Thank you, Your Honor, very much.
Ms.
Okay.
Olivares, I'm preparing that temp order right now. I'll send it over to you via email. Give me about an hour or so.
Okay, I'm gonna call you on the last issue. Thank you, Your Honor. Have a blessed day.
Thank you. Likewise.
you.
Y'all take care.
Thank you, Judge.
You too.
Okay, so the only case we have is CL 184836-I, Portfolio Recovery Associates versus Ruby Mora. Portfolio Recovery Associates versus Ruby Mora. Portfolio Recovery Associates versus Ruby Mora. Okay, the names of both parties being called out 3 times and no response. This case is dismissed for want of prosecution. And that concludes this morning's docket.